Okay, Clayton, are you there?
Yes,
No, not Steve Clayton. I'm sorry. Clayton Priest, the hearing officer.
I am here.
Okay. I think we've got everybody where they need to be. We're recording and we're ready to start.
All right, thank you. So there are three matters. You're here for the Salt Lake City Planning Division Appeals hearing. There are three matters on the agenda this evening. We're going to proceed with them in the order that they are listed on the agenda that was issued. The first is the appeal of a building permit at approximately 1072 South Bonneville Drive, case number PLNAPP 2025-00978. While this hearing is open to the public, it is not a public hearing, and I want to make it clear for those that are participating. What that means is the property owner, the appellant, and the city are able to present and provide me with information, but we're not taking general comment or comments from the public, which is why they've been placed in separate rooms. I have reviewed and I've thoroughly reviewed all of the materials that are submitted. So if you're making a presentation, you do not need to reiterate what's been provided in those materials. For all those that are participating, I have to make decisions based on legal standards. And so if you can focus your comments this evening on whichever way you want the item to turn out, how the legal standards require me to make a decision either for or against whatever provision you're here for. That's what's the most helpful for me, and therefore the most helpful to you in moving these cases forward and understanding what needs to be evaluated. That being said, I would like the parties to make their appearances. So for matter one, this is the Oak Hill Gardens Condominium Association, Bonneville Drive. Those that are here on behalf of the appellant, Oak Hill Gardens, whoever is going to be presenting, and if you have legal counsel, please state your name for the record.
My name is Peter Fillmore. I'll be presenting the narrative for Oak Hills Gardens Condominium Association.
And do you have the ability to turn your video on?
Okay. Recording.
The camera is not working for some reason.
Okay.
I apologize for that.
No, that's fine. We can proceed without that then.
Tell
Is
me,
there anyone else that is here representing that'll be presenting on behalf of Oak Hill Gardens?
No,
Okay, thank you. Anyone on behalf of the landowner?
Yeah, you have Joe and Julie Cooley here, and also Steve Clayton, who's our counsel. If he can, make comment if and when necessary relating to anything in regard to, a legal comment.
All right, thank you. As you're represented by counsel, counsel will have you direct all anything on behalf of the Coolies. If there's anything that you need to elicit specifically from them, you can go ahead and ask them. And then on behalf of the city.
Yes, Catherine Pasker, Senior City Attorney with the Salt Lake City Attorney's Office. I'm here representing the Planning Division. Just so that we're aware, I don't think it'll affect this first matter, but I wanted to let Mr. Priest, that I have a medical issue that will make me temporarily unable to be on camera about 7 p.m. I'll still be here available to answer questions and listen into the proceedings. I just won't be able to be on camera for a period of time if we're still in the subsequent hearings.
Okay, thank you for that notice. So with that, Mr. Fillmore, I'll turn the time to you. Again, I've reviewed everything thoroughly. I've reviewed what you've already submitted. So please proceed, but focus on the legal elements.
sure. And hit share.
I'm going to share my presentation with you.
Here. And share.
Um, Oak Hills Gardens was built in the early 1970s and is a community of 32 primary residences in a very quaint, upscale, and well-established neighborhood. Most residents are in their 70s, 80s, and even we have 6 in their 90s. We're going to go through the 4 things that we submitted. First is we feel the project violates the terms of the city-owned storm drain easement. The HOA is not privy to what has been submitted to the Salt Lake City or the public utilities by Joe and Julie Cooley concerning the building of pickleball court over the easement. The easement, however, clearly states that grantors may construct improvements or landscaping except for trees and permanent structures, buildings, and fencing within the easement as long as such improvements do not interfere with the city's access and use of the easement. The Cooleys proceeded to build a post-tensioning concrete slab that encroaches over the easement. In an email dated 12/20 of 24, Ms. Lima, planning manager and zoning administrator, a pickleball court is an accessory structure and a game court. It is the HOA's understanding that Salt Lake City codes require post-tensioning concrete design and construction to comply with the 2021 Utah building codes, which are based on the international building codes and standards set by the Post-Tensioning Institute and in compliance with the American Concrete Institute, ACI 318. The Post-Tensioning Institute considers a post-tension concrete slab to be a permanent and durable structural solution and is used for construction expected to last for decades. The American Concrete Institute is the document that presents the requirements for design and construction of the structural concrete. The HOA believes that the as-built pickleball structure violates the easement. In addition, the storm drain pipe could have been adversely affected by a large equipment excavating and tamping down for the base of the court itself, which should be inspected for possible damage. This diagram is supplied. Clearly shows that the easement is covered by the sports court.
Mr. Fillmore, is the HOA, are they a party to that easement?
The easement, there's another easement that goes along. No, we're not parties to that easement. The
Okay.
answer to the question is no. It's between the Cooleys and the Salt Lake Public Utilities. Did that address your question?
It did, thank you.
The second issue is noise pollution. The HOA realizes that a violation of noise pollution can only be followed up after an occurrence. However, for the last 16 months, the HOA has consistently communicated to Cooleys that the expected noise pollution is the main issue with the Cooleys backyard landscaping plan. Studies of noise pollution caused by the pickleball, as documented by National Pickleball Association and others, are well documented that a dBA of 70 at 100 feet is typical. The Cooleys Court, as built, is 16 feet from the closest residence and within 100 feet of multiple units. This would include operable windows in master bedrooms, upper and lower decks, front rooms, and even dens and studies. Given the proximity to residences, it is the HOA's belief that the dBA will far exceed the 60 dBA allowed under Salt Lake County Regulation number 21. The Cooleys have stated in hearing records that the court will be used by family members for typical residential recreation and they intend to comply with all city and county noise ordinances and be a good neighbor. Salt Lake does not have any noise requirements specific to residential sports court use. Note, the city does have a noise pollution ordinance, but defaults to the county regulation number 21. Here's the table of the maximum permissible sound pressure levels as of November 6th. They upgraded these regulations on November 6th of this year. So these are the latest ones. Type B is where the condominiums fall in. The daytime maximum would be 65 dBA or 10 above the ambient, which is ever greater. We did do an ambient study, and our ambient study was 47. So this one would be overridden by the 65. However, pure tone and repetitive impulse sounds, there's a reduction by 5 dBA between the hours of 7 and 10. Pickleball falls into that pure tone and repetitive impulse sound. So the maximum dBA allowed would be 60 dBA during daytime hours, 45 during nighttime hours. These pictures show the proximity of homes to the court. This is the court itself. It's already been constructed. being finished. This is the front of the house where the den or the living rooms have been placed. These are all operable windows, and a lot of times they're open, depending on the sun. This is the court here. This is the closest residence. It's 16 feet from here to here. The property line is 11.8, an additional 5 feet. These windows are the master bedroom of the residence, and the windows are operable horizontal sliders, and they are open almost every night because of the prevailing winds up Emigration Canyon as a way to cool the house. These windows are in the lower walkout basement recreation room, and again, they're open. This is the back side of those residences. Here's the court. This is 52 feet right here. These are, again, the master bedroom. These are open almost every evening due to the prevailing winds from Emigration Canyon and a way to cool the house. And most of them are left open till at least noon every day. These are decks. Next shows 2 decks side by side. This is 82 feet from the court. This is 52 feet, 56 feet from the court. People spend a lot of time on the decks, upper and lower, and we find them that the sound will be very intrusive. We'll go into the third complaint now. It's the appellant's claim of the location of the footings for retaining walls and the basketball footings. Based on information from the building services, footings and retaining walls should be considered an extension of the court itself and thus should be set back to 5 feet from the property line. Reference number 10, zoning from Paulo Alameda, which we've met with several times. On 10.1, a game court may be placed within the required yard, but it must be at least 10 feet away from the property line. Since both the game court and its surrounding buffer areas are below ground level, they are considered part of the court itself. Please update the site plan to show the correct distances. The appropriate distance would be from the nearest retaining wall of the court to the property line. Joe Cooley on 10.10. I am still a bit confused on this setback. I always understood this as being the setback from the line of play, which is what the plan shows. I will submit for additional review. Paulo. As our phone conversation, the edge of the game court is considered part of the court, thus requiring a 10-foot setback. The original comment still stands. The HOA realizes that the setback requirement was changed by zoning from 10 feet to 5 feet. I left the 10 feet in because that was his direct quotes. However, it does not change the fact that since both the game court and its surroundings buffer areas are below ground level, they are considered part of the court itself. The appropriate distance would be from the nearest retaining wall of the court up to the property line. So that's direct quote from Paulo. The HOA believes this ruling is counter to the staff report because the staff report does not take into account that the game court and its surrounding buffer areas, including the retaining wall, are below ground level. The permit issued and architectural scale drawings, as well as the staff report, shows the 5-foot setback from the edge of the court, not the line of play, to comply with 21A 36020B, which describes the setbacks. Since both the game court and its surrounding buffer areas, including the retaining walls, are below ground level, they are considered part of the game court as referenced above. The patio area and other walls mentioned in the staff report are separated by stairs and walls and are not part of the game court. Secondly, appellant claims that the permittee added lights in the basketball footing that are not on the approved plans. Cooley's proceeded to install without a permit the basketball footings, which violates both the 5-foot and the 3.5-foot setback. The basketball standard footing was installed without approval and not on the approved building permit. In addition, the basketball footings were poured and included as part of the court itself, which would require a 5-foot setback, as it would be an extension of that court itself and be a setback 5 foot from the property line. As shown by the attached photos, the retaining wall is 3.5 feet, 42 inches from the property line, which is what the plans show. However, the basketball footing is only 37 inches from the line. If you determine that the 3.5-foot setback is correct, the basketball footing still would be in violation of either setback. This is the court as it stands today. These were the light fixtures. There's 2 of them, one back here, one right here. Here's the basketball footing, and here's the retaining walls that were put up, and here's the ground level. They had to backfill because this was below ground. This was all excavated here. There's the dirt pile, and there'll be walls and stairs. You can see the stairs coming down to here.
On this image, is the property line approximately the location of the orange fence?
Yes. See this little pink line?
Okay.
It's right there, yes. And this is 3.5 feet as the plans show to the property line. But this is only 37 inches, and I have a close-up picture of that one. This shows it again a little clearer. Here's the basketball, and here's the sitting, and then they started, and we still need the backfill back through here. This is going to be stairs and the retaining walls from the upper deck, which is not part of the court itself. This shows the basketball footing when it was framed, and they did not frame the front of it because when they poured the court, here they included, you can see they got a little piece of rebar here, and the cement, this footing was made part of the court itself. Otherwise, they would have had to have a framing piece in front. So when they poured the sports court or game court, they allowed that to flow in, and then they set the footing for the basketball court. And again, it's framed on 3 sides. I believe this was the piece that was up front and it was taken out. I don't know that for sure. Just it's about the right size. But it was poured at the same time as the foot, therefore, as the court itself. So we contend that that's really part of the court itself, and it should be 5-foot setback. This picture shows a close-up of the retaining wall, which is 42 inches from the property line. This is the footing after poured. It's approximately 37 inches from the property line. I've got a quick summary. The easement, the hearing officer should have the authority to review to determine how public utilities allowed a post-tension permanent concrete structure to be built over the easement. We would like to suggest that the hearing officer discuss the need for an inspection of the 50-plus-year-old storm drain pipe to determine the status after all the excavation by the heavy equipment and tamping down the base of the court with heavy machinery. The noise. All we can say is the Coolies have stated at hearings the court will be used by our family members for typical residential recreation. We intend to comply with city-county noise ordinances and be good neighbors. Salt Lake City does not have any noise requirements specific to the residential sports court use. Note, the city does have noise pollution ordinances, but defaults to the county regulation 21. I hope they can do what they say. Retaining wall setback should be set back 5 feet, not the 3.5 allowed. Supporting documents indicated that since both the game court and its surrounding buffer areas are below grade level, they are considered part of the court itself. The appropriate distance would be from the nearest retaining wall of the court to the property line, which would be a setback of 5 feet. The basketball footings were installed outside the approved building permit. The Coolies on their own initiative installed the footing as part of the court itself, as we showed by the framing, and located 37 inches from the property line. The location violates the 5-foot setback as the footing was made part of the court itself. If the 5-foot setback is not enforced, it clearly violates the 3.5-foot setback. The fitting should be eliminated and moved to a location on the south side of the court, which would not be in violation of the setbacks. Thank you for your time, and that's our presentation.
Thank
Questions, please?
You've already answered mine, so thank you very much. Mr. Clayton, I'll turn the time over to you as the representative of the property owner. If you could focus your comments on the setback issues, I think I've got a good understanding of the easement and noise pollution issue. And in my mind, this really comes down to the setbacks. So if you can just focus your comments on that.
Clayton, this is Joe Cooley. Quickly, could I give a little bit of background on some of the comments from the Paulo the planner?
Yeah, go ahead.
Okay, just going back on that, a lot of those comments that are cited by the HOA were comments from an original plan that was submitted to Salt Lake City. Since that point in time, the plan's been updated so that the court would not be completely below grade as the original plan showed. A lot of that was based on, feedback from the public utility, feedback from the city, things of those nature. So court was brought up a little bit so that it would be considered at grade. Grade level is mid-court, and that's why there is some retention on what would be the east side of the court, but no retention on the west side of the court. So, two separate structures, two separate pours, two separate things. But at this point in time, those comments from Palo are based on a plan that was not ultimately approved by Salt Lake City or planning or the public utility. So that's the change in that. So those are old comments from a prior plan. And then also, if you look closely at the close-up picture he took, the footing for the basketball standard was poured at the same time, but it was separate. You can see there's a separate, I don't know what you'd call it, but it's like an expansion joint in there. We have sent in an updated plan as it relates to the basketball standard and the lighting. That's in for review right now. We do have feedback from planning stating that footer can be outside of the 5 feet, but it needs to be below grade. It will ultimately be below grade. And when or if we decide to put a basketball standard up, we'll make sure that it will be the 5 feet from the pole to the property line, which is what the zoning has commented to us as it relates to the most current amendment to the plan. So hopefully that helps answer some of the questions as it relates to the comment and the retention around the court.
All right. Thank you for providing that clarification.
Yeah, I really don't have a lot to add as to the staff's report. I think the staff's report covers well the issues at hand. All of these structures have been duly approved by the building and planning department and built according thereto. And so if you have specific questions about the setback or concerns that you have in particular, be happy to address those together with the Coolies.
So just to be clear, so and this comes from the staff report, and we can have the city comment if we need to. I'm looking at page 5 of that staff report that has the excerpt from the plan, and it shows a green area, a shaded green area, and I want to understand that green area is going to be grass, landscape, something of that nature. And is it the white rectangle? Is that the actual concrete that we're talking about?
Yes. As I
Okay.
understand, Joe, would you like to confirm that?
Yes, I'm sorry, I'm not looking specifically at the staff report right now, but that is the way
Yeah, and you can see from that the court lines are well inside that pad, that concrete pad. So the pad is 5 feet from the property line, with the court lines being an additional few feet within that pad.
And that's what I wanted to make sure I was understanding was if the green court line were within the pad or if that was the pad itself.
Yeah, that's correct. The green court line is the court line within the pad.
Okay. Thank you. And that's all the questions I had for the property owner. The city, we'll turn the time now over to the city.
My name is Noah Elmore. I'm with Salt Lake City Planning Division. I'm a principal planner, and I will be presenting our oral arguments. Just share my screen.
And as I've commented, I've gone through the staff's report in quite a bit of detail. The only thing that I would like you to address from the staff report, unless there's something else that you feel like based on comments that have been made this evening that needs to be addressed, is the setback issue.
Yeah, I can pretty succinctly cover the issues here for you and touch on that setback. So I'm going to give some high-level overview just to make sure we're all on the same page. So in claim 1, the appellant alleges that the sport court's, the permanent structure as such, it's not permitted to encroach into the storm drain easement. That easement is administered by the Department of Public Utilities, not the Planning Division. Therefore, the permit was reviewed and passed by Public Utilities, not the Planning Division. Subsequently, as noted, the appellant is not a party to this easement as well. So interpreting or enforcing this easement is outside the scope of review for this hearing. Claim 2, potential noise violations. Those cannot be enforced upon, as the potential for noise violation is not the same as a realized noise violation. So even in the event of enforcement, Salt Lake Valley Health Department regulates noise control in Salt Lake City, not the planning division. Ultimately, there are no standards in Title 21A, which would preclude issuing a permit on the basis of a hypothetical noise violation. Given that hypothetical noise violation is impossible to enforce upon, and the noise control regulations are not administered or enforced pursuant to Title 21A, this claim is also outside the scope of review. So claim 3 regarding the setback. The appellant claims the footings and retaining walls supporting the court violate setback requirements. Regulations pertaining to game courts are set forth in section 21A 36020.b, which stipulates swimming pools, game courts, and similar uses, when located within the rear yard setback, are at least 5 feet from all lot lines. Title 21A does not define game court as referenced there. However, per section 21A.62.010, we then refer to Merriam-Webster. Merriam-Webster, among other things, defines court as a, quote, quadrangular space, walled or marked off for playing one of various games with a ball, such as tennis, handball, or basketball, end quote. Therefore, the setback for game courts is measured according to the markings of the external boundaries of the court, not any infrastructure surrounding it. The site plan submitted as part of the subject permit documents how the delineated area of the court appears to be several feet, as you just noted yourself, in excess of the required 5 feet from the nearest lot line. Because the location of the court itself is more than 5 feet from the nearest lot line, it complies with the setback standard established in section 21A 36020B. The other infrastructure surrounding the court includes a patio on grade, landscaping, or wall infrastructure, all of which are permitted encroachments within rear yard setback.
And the patio on grade you're referring to, is that the brown hashed area?
That would be the white concrete.
Okay, that's the patio that we're referring to.
Correct.
Okay.
So, also, as it relates to the basketball hoop and the lighting, based on preliminary analysis of the drawings that were submitted for permit review, a proposed basketball hoop with lighting that also complies with the minimum 5-foot setback. So with all of this in mind, the appellant has provided no evidence that the game court does not comply with the 5-foot setback as documented on the approved and stamped plan set. So therefore, appellant's claim is without merit and should be denied.
In the 5-foot measurement, sorry, if you can go back, the 5-foot measurement is from the property line to the edge of the concrete pad. Am I understanding that correct?
Correct. So for all the aforementioned reasons, the appellant's arguments must be rejected and zoning approval of the permit be upheld.
Thank you. I did have one question, and this is a procedural issue. Ms. Pasker, you may need to comment on this. So this is actually, so it's page 8 of the entire document that's the staff report. It's the acknowledgement of, the title of the page is Acknowledgement of Responsibility. It's part of the application information that was submitted for the appeal. My question is, since this is an appeal that was brought by an HOA, there's a legal property owner consent portion of that that's not filled out. And I'm looking at subpoint 3 that says if a homeowner association is the applicant, then the representative/president must attach a notarized letter stating they have notified the owners of the proposed application. A vote should be taken prior to submittal, and a statement of the outcome provided to the city along with a statement that the vote meets the requirements set forth in the CC&Rs. Is that provision applicable in this appeal?
Thank you for the question. I believe we did receive some additional, statements from members of the HOA in support of this appeal being filed. And on that basis, we moved the appeal forward with the HOA as an interested party.
Okay, thank you for that clarification.
And I would comment, I mean, that is an important point as far as what the approval requirements are and how that's authorized is for standing on behalf of the HOA as well.
We did ask that in the prior appeal, what those standards would be. I don't know if we ever got an answer as it relates to that.
And I'll turn the time back over to you, Mr. Fillmore. If there's anything that was raised that you want to briefly address.
Well, I believe the offset question is the real question at hand. The reason that they said that is below ground is because they had to move a tremendous amount of dirt. If that court was required to move 5 feet back up east or up towards the patio, which is not part of the court, it's about 4 or 5 steps above the court. That's why those retaining walls were put in, because they had to excavate a ton of dirt. You can see the mounds of dirt in the photos that they excavated out there to make it a level playing court. So we still contend that retaining wall should have been at the 5-foot limit because it is part of the court. Without that retaining wall, our entire landscape would drop 4 feet. They excavated down a good 4 feet to put that court in. And the footings are below the court for the retaining wall. And so that's our thing, that we believe that they are part of the court itself.
Thank you. So with that, I'm going to take the matter under advisement. And the way that this process works is I will go back through my notes that I've taken while we've been discussing. I'll also re-review the submissions, and then I'll be issuing a written ruling. Typically, it's within the next 10 days. Given the holidays next week, that may be delayed slightly, but you should expect to see something within about the next 10 business days.
Thank you.
Thank you.
Thanks.
Thanks very much. Thanks, Noah.
With that, we'll now move to the second matter on the agenda. This is the David DeVicchio, and I apologize if I'm not saying that correctly. It's case number PLNA-PP 2025-00938. Will the parties please make their appearance, and we'll start with the applicant.
We can't hear you, Dave. My name is Janelle Bauer. I am counsel for the applicant. And I believe his last name is pronounced Dave DeVecchio.
Let me know if you guys can hear me
Oh,
now.
there he is.
Yeah, my last name is pronounced DeVecchio, so good to
I
meet you.
apologize.
It's okay.
Thank you, Ms. Bauer. From the city, same.
Same, Catherine Pasker.
Any change in the lineup?
I'll just mention I was having technical difficulties. I'm Daniel Echeverria, the zoning administrator, also for the city.
All right. So again, give me just a second. I'm going to switch over my notes. I keep these in different places for the different appeals. I've reviewed the staff report. I've reviewed the public comments that were submitted. I've reviewed all of the information that's been supplied by the applicant. As I noted before, there's certain legal standards that I have to look at, so it's most helpful for me if you can focus on those. With this case in particular, I would, Ms. Bauer, if you can focus on, as I see the issue, and the issue that's in most conflict in my mind is the definition of dwelling that's used in city code as well as in the Brown versus Sandy City case. And to me, that's what this seems to hinge on. So go ahead and present what you'd like to present, but if you could pay specific focus to that dwelling definition.
Sure, thanks. And first of all, I wanted to apologize to Mr. Elmore for confusion earlier this week. I asked him to change, if we could change the order of the presentations tonight, and then I sent him an email that was kind of unclear, asking if it was possible to move us, and he just went ahead and did that. He was being helpful, and I hadn't actually talked to my client about getting us moved yet. I was just asking if it was possible, so I apologize for the confusion on the agenda. And to Mr. Elmore, I caused a lot of stress probably for him earlier this week, so I apologize. But yeah, the crux of this argument is whether the short-term rental use was legally established prior to 2023, when the ordinance was changed to prohibit those uses in this zone. And specifically now in the staff report, the planning staff is relying on the definition of dwelling in Salt Lake City Code. Prior to that, though, in the decision to deny my client's application, they tried to argue that a short-term rental was more like a hotel or a bed and breakfast. So a lot of our appeal is focused on that issue, but I will address the dwelling definition. So if you'll look at the code, there are definitions of what a single family residential dwelling is, or that use is, which is a detached building containing only one dwelling unit surrounded by yards that is built on a site, or is a modular home dwelling that resembles site-built dwellings. And then it goes on to say that temporary buildings, like mobile homes, travel trailers, are not dwelling units. It also defines family, and then defines what is the character of a dwelling. And that's where we get this definition that says a building or portion thereof, comma, which is designated for residential purposes of a family for occupancy on a monthly basis, and which is a self-contained unit with a kitchen and bathroom facilities. The term dwelling excludes living space within hotels, bed and breakfast establishments, shared housing developments, boarding houses, and lodging houses. So it's these words monthly basis, which now the staff report is claiming that the short-term rental use of a residential home was prohibited prior to 2023. I would argue
Can I
that
ask
this
real quickly, prior to 2023, is this the same definition that was in place? Are we dealing with a change in ordinance during the time at this 2023, or is this the same ordinance, same language that's been in place since your
From what I was
client
able to
operated?
determine, and maybe Mr. Echeverria or Mr. Elmore can explain that better, but from what I was able to determine, this is the same definition that was in place in 2018.
Thank you.
With that said, though, this definition seems to be describing what the characteristics need to be of a dwelling to make a dwelling unit. It needs to be of more permanent nature. It can't be a place without a kitchen or a bathroom, but that would be conducive to people staying in that residential dwelling for longer than 30 days. It does not require a certain leasehold estate by the family. It does not say that the rental can be, is prohibited if it's less than a monthly basis. It just says that it needs to be the type of a residential building that would allow someone to stay there for longer than a month. And then it specifically excludes hotels, bed and breakfast establishments, and places that are not conducive to living in for longer than a month. But it does not prohibit or expressly ban short-term rentals. And in fact, Mr. Priest, I would say that why did Salt Lake City need to then prohibit short-term rentals in 2023 if this provision was intended to do so?
But I've got to give meaning to the words on a monthly basis.
Right. So and I think
specifically added by the council.
I think you can, because they're describing what a dwelling is. It has to be something that's more permanent, not temporary. It's not a tent. It's not a hotel room. It has to have a bathroom and kitchen facilities. And if you look at that paragraph as a whole and read it as a whole without just taking out that monthly basis part, it is not talking about the leasehold estate that the family has to have. It is describing the nature of the residential dwelling itself.
But there are hotel rooms that have kitchen facilities, that have lounge facility, a living room for all intents and purposes, and a sleeping unit. And
Yes.
so it seems if you look at that and you say, well, a dwelling has to be for occupancy on at least a monthly basis, so that would then mean that that hotel room wouldn't constitute as a dwelling. Isn't that a valid interpretation of this definition?
I don't think so, because then it should have been expressly prohibited, as you see in the Brown case. And also that provision should not be read to restrict my client's use of his property. I mean, he's an innocent landowner here. He bought this property in 2018 when it was already being used as a short-term rental, and just continued that use. He had no idea that that use wasn't even allowed until he was contacted by the city this year. And I really think that this defining dwelling as a home that is capable of being lived in on a monthly basis means the character of the home itself, with a kitchen and a bathroom, and it distinguishes it from hotels or bed and breakfast establishments. It does not distinguish it from a short-term rental. It doesn't prohibit short-term rentals. It just says it has to be of the type and character of a building that you could stay in that long. But there's no requirement that a family couldn't stay there 15 days and another family stay there 15 days, and that's a monthly basis.
With regards to the Brown versus Sandy City case, so in Brown versus Sandy City, and I went back through this before this hearing. In that case, and for the record, it looks like I'm on page 211. The court notes that, quote, both parties agree the code never places an express durational limit on the use of any property. So when the Brown court was reviewing the definitions, both sides in that case are saying the code here doesn't talk about duration. Does that distinguish Brown? Is Brown still applicable?
I don't think so, again, because there's no leasehold estate required in Salt Lake City's code. This is a definition of the term dwelling only, and what constitutes a dwelling, not what constitutes residential use.
Thank you. This is a tight area given the way that I have
Right.
to.
And I think it's in, the code is ambiguous with that language. It is. But then if it is ambiguous, according to the case law, Brown and the cases cited in that, my client should not be the one to suffer the consequences of that ambiguous language. It should be interpreted that he is allowed to continue the use.
So I want to drill in very specifically on this. What about the definition of dwelling do you think is ambiguous?
I would say that the monthly basis language is the ambiguous part, because you've got your interpretation. Well, I mean, Salt Lake City has their interpretation of what monthly basis means, and they're trying to now rely on that in the staff report, which is not something that they relied on in the initial denial. But now they're trying to rely on that in the staff report to claim that this use was never legally established. But this is just an accessory use to residential, use of a dwelling that people have been doing forever and ever, renting their private dwelling to a different family.
If they didn't raise this argument about monthly basis in the staff report, are you taking the position that they're barred from raising it now on appeal? Did they waive
They
that
didn't
argument
raise
by
it
not?
in the staff report, but my understanding is this is de novo review. If that's incorrect, I'm happy to say that they cannot raise that issue in the staff report. But I do think the standard of review is de novo.
And that's what I'm trying to understand, if that's something I need to rule on or not. And I want to make sure I
Yeah.
understand
I
your
mean,
arguments.
I would love to tell you that, yes, you can't look at that, but I do believe that the standard of review is de novo. So,
Yeah.
so.
And sorry, I have been sort of hijacking your presentation, but what else would you like me to consider?
Let me just look at my notes really quick. I mean, that was the crux of my argument. That is the legal issue. I don't know if there's much more to say.
I have a question about Exhibit E to what you submitted. And that's the map that shows the uses in the proximity.
mhm.
And the question, oh, go
Oh,
ahead.
sorry, go ahead. Well, my client wanted to include that map. So he's in this area that, yes, it is zoned as residential, but on this block, there are numerous mixed uses, right? You can see it from that exhibit. This isn't a situation where this short-term rental has moved into the middle of a purely residential neighborhood. This is a mixed-use neighborhood with old residential zoning on my client's property. And also all of the neighbors that he has spoken to are, you know, in favor of him continuing this use. He lives right next door. This isn't an absentee landlord situation where he's got people in there and he's not, you know, watching and making sure that they're using the property correctly. He is right next door. So he's a good property owner. He's good for the city. He's allowing people to come in and visit their families in Utah and stay in this home, you know, with nicer accommodations than they would have at a hotel.
And so on Exhibit E, I just want to make sure I understand it. The contention's not that everything in that map area shown in Exhibit E is part of the same SR1A zone. It's that the nature of the neighborhood generally allows mixed use. Am I understanding that argument correctly?
Yes, yes. Just the nature of the neighborhood is commercial. I mean, if you take a look at that, it just is. This is a remnant of residential zoning in what is now really a mixed use zone.
Thank you. Anything else?
Again, I think you can also look at the Patterson versus Utah County Board of Adjustment case. It's cited in the Hugo versus Woods Cross case that I mentioned to use the proposition that restricting the uses should be strictly construed in favor of the property owner. So you should find that my property owner, my client, can continue to use his short-term rental as he has been because it was legally established before 2023 when the code changed. It was used as a residential use and it always has been, and renting your property is not prohibited, and therefore he should be able to continue that use.
Thank you. I'll turn the time, the city, whoever's going to be presenting on behalf of the city.
Yeah, I'm just going to jump in very briefly to try and respond to the few questions you raised, Mr. Priest, before I let Noah do his brief presentation. But just, you know, as a matter of process, obviously, you know, the staff report, or excuse me, the administrative interpretation, which is, you know, the decision that was appealed, went through the typical, you know, zoning analysis, right? It analyzed, hey, the, you know, property owner alleges that this, you know, short-term rental use was commenced in 2018. I don't believe that the city is disputing that. Was, you know, short-term rental an allowed use in the zone in 2018? No, it was not. Okay, then we look at the land use tables. What factually is that use most closest to in terms of the defined use in city code? Planning says, you know, that's a hotel or bed and breakfast. Okay, were those allowed uses in the zone? No, they were not allowed uses in the zone. Therefore, the short-term rental use was not legally established when it was commenced in 2018. And that's why you see that analysis in the administrative interpretation and not a discussion of is short-term, is a short-term rental use, comprised within what it means to be a single-family residential use. The presentation and the discussion is different in the staff report because the staff report is responding to the claims made in this appeal that were raised specifically by the appellant, in response to the decision. Staff isn't going to write an administrative interpretation necessarily, trying to anticipate any and all claims that might be raised. That's why we have de novo appeals, so that we can, here's the staff decision. Yes, the, appellant can raise any and all claims that they think are, must and should be raised to appeal an administrative decision, and then the city responds in the staff report. And so that's why you see, some things being, addressed in the staff report that were not in the administrative interpretation. And, obviously ignorance of the law is not a defense. Short-term rentals not being an allowed use when it was commenced, it was not a legal use. And just because that use wasn't defined until 2023 didn't make it legal in 2018 when it was commenced. The city, believes you're completely correct in pointing out, we must give effect to the language and the definitions in their, logical plain meaning as Utah law dictates. And occupancy on a monthly basis doesn't mean, as the appellant would contend, as capable of being occupied on a monthly basis in some sort of structural way. Any space with a bathroom and a power outlet to operate a hot plate could be, capable of being occupied on a monthly basis. It's, what is in fact the period of occupancy? And the code requires that period of occupancy be on a monthly basis. And it must be for residential purpose. And, the appellant has admitted that this is not a residential purpose. This is a hospitality purpose. And the city, needs to acknowledge that is the use, and that's, pretty undeniable based on the facts here. And that's because it's not a residential use. It doesn't comply with the definition of dwelling.
With regards to, I'm going to start with the question of residential versus hospitality uses and drawing a distinction there. In reviewing Brown, Brown seems to indicate, because it was short-term rentals in that case, single-family residence, and that court, in looking at it, seemed to lump short-term rentals as a residential use. Am I not understanding that correctly from Brown?
So on Brown, my understanding is the only issue on appeal, they had kind of, set aside the issue of, residential use that was kind of raised below, but it seemed like it was, dropped on a, subsequent appeal. And it kind of the only issue before the court was the durational requirement. And, the parties kind of couldn't dispute that there was no durational requirement in the code. And that's, why the court, sided ultimately with the appellant in that instance, that the court couldn't read a durational requirement into Sandy's code that just simply didn't exist.
Okay.
Obviously, that's not the case here. There is a durational requirement. And so the city would contend that case just simply isn't applicable.
So in going back to the definition of dwelling, and the second part of the definition where it talks about the term dwelling excludes certain types of living spaces. So living spaces within hotels, bed and breakfast establishment, shared housing developments. Is the city's interpretation of that exclusion to refer to, there are hotels that have long-term residences within them. So is the city's interpretation of that second part of dwelling exclusion, is it's referring to or part of the bed and breakfast where the host lives. That's the dwelling that's intended to be excluded.
So it's giving uses that are defined in the code and making very clear that those uses cannot be considered dwellings, even if people may happen to occupy them for more than 30 days. So an extended stay kind of situation, extended stay hotel does not become a dwelling simply because someone, a family may occupy it, and have, if they're living there, they have nowhere else to go for more than 30 days.
So if just want to make sure I understand the way the city's interpreting this term. So they're saying that a dwelling excludes whatever living space someone in a hotel might, if somebody stays in a hotel they stay there for 31 days in the hotel, that by nature of that does not become a dwelling.
Correct.
It remains a hotel. That's the
Correct.
city's interpretation. Okay.
So sorry if I
Mr. Priest, oh, sorry, Catherine, I didn't realize you were still going to talk.
well, I didn't want to take all of the time from the planning division. I know Noah has prepared a presentation. So if the hearing officer would like to hear that, the city would give the balance of our time, or obviously we'll happy to respond to more questions.
I would. Again, on these legal definitions, it's helpful to me, and I know there's a little bit of back and forth, and that may be unusual. But Ms. Bauer, if you have a comment specifically related to this legal interpretation of dwelling, I would like to hear that now, just so I can keep everything in the same compartment as I'm reviewing this.
So if you take a look at Utah Code 10-8-85.4, you can see that the state of Utah and the Utah legislature have defined short-term residential use as a residential use. It doesn't specifically relate to this argument necessarily, but I want you to know that under Utah Code, the Utah State Legislature has specifically said that short-term rentals are a residential use of property.
And I want to look at that citation. So you said it's 10-8-85.
85.4.
85.4. Thank you.
It defines short-term rentals as a residential unit. And I think that, using a home as a short-term rental is a fundamentally residential use. And the use, which we're talking about, which was legally established prior to 2023, is using it as a single-family dwelling unit, which does not have a time limitation in that definition. That definition is found at 21A.62.040. There is no time limitation or no leasehold requirement for the family. That is the use. The definition of dwelling brings ambiguity, but again, you can read that definition to mean the character of the dwelling has to be something that would allow somebody to live there in a safe and healthy manner for longer than 30 days.
If I can respond to that.
Yes, please.
Even just more specifically on the 10-8-85.4, that does not, there's no indication in that section that it is a residential purpose. Like, we acknowledge, the city is not trying to be obtuse here. Like, we know short-term rentals exist. That's why they're in our code. We know people rent their homes out, as a commercial enterprise, and that is allowed in some portions of the city. But just because some people do it doesn't mean it complies with Salt Lake City zoning laws. And in order for a use to have legally existed, it must comply with the definitions applicable to the use as applied by the land use authority. And the land use authority in this case is Salt Lake City's definitions. in Title 21A. And so those are the applicable definitions, not extraneous other definitions in state code, that didn't exist and are, not the relevant definitions that need to be applied to the use in this case. And we need to apply the plain meaning of those definitions, which clearly require both a residential purpose to the use and a monthly occupancy, and both need to be met, and both have not been met in this case.
And so if I was, and be clear, so both have to be met. So if I find that the use is residential, but the monthly occupancy doesn't exist, then under city's code, I would be required to find that it doesn't comply with, it wasn't a legal conforming use.
Correct, because it is not, because it's in violation of, Salt Lake's definition of dwelling that is applicable to the single family dwelling that this property is recognized as.
All right. I think I understand the city's position on this. And thank you both for the back and forth. That is helpful. Mr. Elmore, is there anything you'd like to add now that we've the lawyers have had their turn?
I think I can add and maybe do a little, maybe not repeat, but emphasize some elements as well. Ms. Bauer was kind enough to read the definitions, so I won't regale you with my invocation of them. But I am going to keep them on the screen here for reference because I will be referring back to them. So, as has been discussed here, the definition here establishes single-family dwellings as a type of dwelling. And I'm not going to read the definition here, like I said, but I do want to emphasize the portion I underlined here under dwelling. A building which is designated for residential purposes of a family for occupancy on a monthly basis. It's not referring to structural components. This is a land use definition. We define buildings separately to refer to structural elements of the building itself, to define what is physically a building. Dwelling is referring to how is the land used, how is the physical structure used. And that's why it explicitly says occupancy, not existing on a monthly basis, because it's to be occupied, not to exist on a monthly basis. It's delineating between those, between a land use and the building simply existing upon the land. So I wanted to touch on that. I also wanted to mention, since the appellant referenced, the possibility of, multiple families staying over multiple periods of time. The definitions here refer to the entire family, while the definition of dwelling also references a family. In both instances, these are singular usages. These are not plural usages. They don't say families may stay here for a monthly basis. It says a family. So again, that's singular. It's not entitling multiple families to kind of come and go as they please. So then additionally, on top of that, we're also delineating here in the definitions between the commercial hotel uses and things like single family residences where you're intended to reside on a more permanent basis. If that wasn't here to intentionally distinguish between commercial uses and residential uses, then I'm not sure what else it would be here for, if not to set that precedent and establish a single family dwelling is a long-term residence to reside in. It is not a long-term existing building. So with that, I think if you were to read this in the plain language pursuant to state code, this would refer to one dwelling with one family occupying the dwelling for a minimum of 1 month. I also wanted to touch on the non-conforming uses. So the appellant is claiming, the subject property here is being treated differently than surrounding properties. The existence of other legally established non-conforming uses is not evidence in and of itself that the short-term rental use is also legally established at the subject property. The Avenues is one of the oldest neighborhoods in Salt Lake City, one of the oldest neighborhoods in Utah. The Avenues has experienced many zoning changes over time as a result. It even predates the original zoning ordinance of 1927. As a result, the Avenues features an eclectic mix of commercial and residential uses. Due to this history, the Avenues, as a result, has a great many legally established, non-conforming uses. There are also a variety of zoning districts present in the avenues, some of which do permit commercial uses by right. However, while short-term rentals and similar uses may be permitted in other zoning districts, they are not permitted in this SR1A residential zoning district. So just to kind of summarize that point, the existence of legally established non-conforming uses at other properties does not establish a legally non-conforming use at this property. I think that covers my additional points on top of what Catherine already touched on.
Thank you. Ms. Bauer, anything in conclusion?
Sorry, I'm on mute. Okay. I did want to say that my client, I learned earlier this week, is facing some fines from code enforcement that I was unaware of. And he's kind of in between a rock and a hard place with that. Because as you know, the nature of a non-conforming use, if you abandon or halt that use, then the use goes away. And he's had this appeal pending. And so we're asking for the city to grant some sort of stay, if you can, retroactively at this hearing, or in your decision on those fines, given that he has been trying to comply, applied for a non-conforming use designation, and was in a place where he would face significant harm if he gave that up, and then won the appeal.
It's my understanding that the appeal in front of me is solely related to the non-conforming use, that the code enforcement, whatever code enforcement action or appeal is not currently in front of me. Ms. Pasker, am I understanding that correctly?
Yes, thank you. I mean, the question before the appeals hearing officer obviously is to decide whether or not, the decision made by the planning division in deciding that the use was not legally established, whether that was incorrect, and deciding on the claims, specifically raised by the appellant. Any, with respect to, abandonment concern, that has to, be for a period of time in order to actually be abandoned under state law. And obviously, ceasing a use to, during the pendency of an appeal. I don't think that would be real jeopardy to say, oh, you've abandoned it in order to get your fine stopped. But ultimately,
and I don't know that I need to get into that. My issue is the code enforcement has a separate appeal process at the city. Am I understanding that correctly?
That's correct. Once a property is in compliance, then a property owner is eligible to go to the fines hearing officer to get some accommodation on, any fines balance.
That's great. I just wanted to raise the issue in case it was applicable to this hearing, just so the city is aware. And also, abandoning the use takes my client's reviews and everything that he's built for his business off of Airbnb and VRBO. And it's not just as simple as, oh, well, you've got a statutory period of time. It actually
I'm going to go ahead and just cut you off. And the reason I do that is this is going beyond the scope of what I'm here to review. Okay. And there's a separate code enforcement appeals process. The issue that you raised is more appropriately brought in front of in that process. It's not something I can rule on here. And so I'm not going to take really positions on either side other than confirming that there's a separate code enforcement appeals process. And so your client is free and welcome, pursuant to the procedures and codes, to apply and raise those arguments in front of the code enforcement appeal, as may be impacted by a decision as to conforming, non-conforming, which is the only thing I'm able to look at. Okay. So with that, then, I am going to take this matter under advisement. And if you were in the waiting room and heard me, I typically try to issue those within 10 days. But given the holiday, I may be a little bit slower than normal, but I will try to issue a written ruling addressing the issues that were not just raised in oral argument, but the issues that were raised in the briefing of the parties. So thank you both, and thank you for the oral argument on this. It was helpful in trying to help understand the definitions and the key issues at play.
Great, thank you.
Thanks.
We will go now to the third item on the agenda, which is the variance request for fence height at approximately 852 South West Temple. Eve Silver, case number PLNZAD 2025-00845.
I'm getting them moved over. Eve, if you could please turn on your, oh, there you go.
Hi,
Great.
I just got
Thank you.
added. I guess I was just a member, a viewer. Okay, and then how do I share my PowerPoint? Sorry, I'm just jumping into this.
There should be a bar at the bottom that has a share option.
Okay, great.
And if I can have the parties, just for the record, go ahead and make your appearances before you start, Eve.
Sure.
So for the applicant, Eve Silver, you're here. Are you represented by counsel?
I do not. I'm just representing myself.
Is from the city, is there anyone different that's going to be presenting that's been presenting in the past, the prior matters that were in front of us this evening?
My name is Eileen Leon. I'm one of the associate planners, and I've been assigned to this, the variance height request.
Thank you, Ms. Leon. All right. So with that, I'm not sure if you heard in the other ones. I have reviewed the staff report. I've reviewed the appeal application that was filed in detail. I do have questions, and as you've probably seen, I will ask those as they come up. So with that, Ms. Silver, go ahead.
Okay, are you seeing my PowerPoint? Did that upload?
I am seeing that.
Okay, so the property was renovated in 2011. I don't have a picture submitted, but in 2015, there weren't any of these buildings that were surrounding me. I had a 4-foot fence. After construction in 2000, I believe it was like 2019, 2020, I have these 4-story buildings, and they are built less than 5 feet from the sidewalk. When the property was under construction, I talked to the building inspector, and he actually recommended the fence that I have installed here, and it's 95% visibility. I had a contractor do it, and so I just paid for it and moved on. When I did the renovations in 2011, I hadn't seen, I just had one review just this last March by the city for code and stuff like that. And so at that point, I was cited for the fence. Never once was this fence ever a problem in the 5 years that it's been up. It's just now coming to my attention, and I'm just now finding out that permits weren't placed for it. And back when I put in the fence in 2000, I want to say it was 19 or 20. I don't have record of when it was done. I just hired a contractor. He installed it. Apparently permits weren't put in place for that. And so now I have a 6-foot fence that was allowed at the time that would have been approved, but now I have to rip it down. The fence, when I originally put it in, was a cost of $10,000. I'm probably looking at a similar expense, or, in the last 5 years, the cost of a fence to go, I would have to completely tear it down. I can't cut that fence down to 4 feet. So I'm going to have to rip out the fence, and I'm going to have to put in a 4-foot fence. But I'm probably looking at about $10,000, which in the world of, rental properties, I don't have that margin to be able to afford a $10,000 expense. And then if I go to the alleged hardship is related to size, shape, or topography of the property for which the variance is sought. I mean, if we get into verbiage, is property talking about just the land, or is it talking about the building? Because if you look at the building in relationship to the other buildings, I'm definitely smaller. Every building on this block -1, because this was torn down, and another 4-story building is being constructed right now. I'm definitely different in size, shape, and topography. If you look at square footage, this is a 30-unit building. I'm a 10-unit building. So my courtyard is like, I'm definitely different than the properties that are surrounding me. And then as far as traffic and stuff like that, if I put in a 4-foot fence, I have a hop over where people will just travel through my property to get to the back access alleyway to where Trax is located and stuff like that. Like, I don't have the advantage of the other buildings that have a solid wall and they have locked access into their buildings and stuff like that. If I take it down to a 4-foot fence, it's not going to prevent somebody from coming onto my property. And I've had to take measures. I put in cameras. I've done all of that stuff to try to protect my property, and I still have issues. And so anyway, as far as this goes, I think I am different in size, shape, and topography if you're talking about the building size. Sure, if you're just talking about the lot, but I just, okay, sure, the lot is the same size, but square footage wise, as far as the building goes, I'm quite a bit smaller. I'm more than half the size. And as far as the fence goes, it's 95% see-through, and it was put in when 6-foot fences were allowed. I don't know. That's kind of the gist of my presentation. I don't know what more I can kind of to present my case.
So there's a few questions I have for you. So 8040 Southwest Temple, which I think is the other property you'd mentioned it's just on the other side of
Yes.
that one. Does that have a 6-foot fence?
It does not. It has a 4-foot fence, and it is a pass-through for people and traffic and stuff like that. But it has a substantial like vegetation and stuff like that. So it's more of a deterrent, I think, for people passing through. And then behind it is a solid wood fence. So the back courtyard is a complete solid wood fence.
And the back fence, is that a 4 or 6-foot fence?
It's 6 feet.
Okay. And then you'd said before the 6-foot fence was installed that there was a 4-foot fence on the property. Did I hear that correctly?
There was a 4-foot fence. During construction, the fence was completely demolished just because construction on both sides of me was extensive. I mean, they took out my water lines and yeah.
And my question is, when you had the 4-foot fence, did you have issues with the hop over or pass through as you've described?
No, because they had other ways to get through. I didn't have these buildings that were blocking traffic.
Okay. Those are the questions I had. Is there anything else that you'd like me to consider?
I mean, no, I think just looking at the like general overview of the buildings, the scape of it, like my building is considerably smaller. So, I mean, if we're talking about the land, but I do feel like property is a little misleading, like, because if I just looked up the definition of property, it says land, building, or both. And so I was going under that premise where my building is considerably smaller. If you're looking at just land, for sure, like I'm actually larger than the 2 buildings on both sides of me, but I mean, the size of my lot does not really affect putting up a fence. It's the buildings built around me. If that makes sense.
Yes, thank you. City.
Eileen has a presentation that she can run through fairly quickly and get to some of the key points.
Okay. Eve, you might have to stop sharing your screen in order for me to share it. It's just not letting me share it.
Okay, can you tell me how to do that?
Um,
Did I
I
just
believe
X it out? Did that do anything for you?
You just have to push the share button again.
Just push it again. Did it bring up?
Is in the bottom of the screen, there should be a green square button. If you click that, then it should bring up an option in a window to stop sharing somewhere.
Okay.
Also, maybe at the top of your screen.
Um,
Let me see if I can.
Entire screen or screen 1, screen 2?
Just one moment.
In that window, there should be somewhere where it says there should be a red square that says stop
Got
sharing.
it. Okay. Sorry, Eva accidentally turned off your video, but I have now stopped sharing your presentation.
Okay.
And Eve, you can still hear us, correct?
I can hear you.
Okay.
All right. Is everyone able to see that?
Yes.
I can see it.
Okay.
Yes.
Perfect. So as mentioned previously, the applicant is requesting a variance to allow a 6-foot fence between the front property line and the primary facade of the building along West Temple Street. Under the current zoning ordinance, fences in this location are limited to 4 feet in height. A 6-foot fence would be permitted behind the primary facade, but not in the front setback area where the subject fence is located. This is a photograph of the subject property. A 6-foot fence is currently on site. My apologies, that is currently on site, was installed prior to 2021, and the applicant states that the additional height is needed to address concerns related to trespassing and illegal activity occurring in the courtyard, particularly due to the adjacent properties to the north and the south that have minimal or reduced setbacks. This is the subject fence, or the fence in question. Staff reviewed this request against the variance standards, all of which must be met in order for a variance to be granted. And while the applicant did meet some of the standards, staff determined that the variance does not meet the required hardship criteria, with the most critical deficiency occurring under section B1. A variance standard has 5 substandards, and staff found that the applicant does not comply with standards A1 and A5 due to not meeting the hardship standards of standard B. Staff was also unable to find the applicant met standard A3, which addresses whether granting the variance is essential to the enjoyment of a substantial property right possessed by other properties in the same district, and I'll review the standards in the next slides. Standard A3 is about how granting the variance is essential to the enjoyment of a substantial property right possessed by other properties in the same zoning district. And staff does acknowledge that safety and security are substantial property rights. However, staff believes that alternative methods exist for security, such as landscaping or security cameras to help prevent trespassing. Standard B governs whether an unreasonable hardship exists. Standard B1 specifically requires that the alleged hardship be directly related to the size, shape, or topography of the property for which the variance is sought. The standard is mandatory and must be met before an unreasonable hardship can be found. Staff did find that standard B2 is met. The alleged hardship comes from circumstances peculiar to the property and not from conditions that are general to the neighborhood. These standards are similar to the standards in Section D, special circumstances. The property is somewhat unique in that it has a larger setback to the adjacent buildings to the north and the south that have little to no setback, which may contribute to potential hiding areas. And because of that situation, staff believes that standard B2 is met. In this case, staff found that standard B1 is not met. The subject property is long, rectangular, and flat, and its physical characteristics are similar to surrounding properties in the area. There's nothing unique about the size, shape, or topography of the property that prevents compliance with 4-foot fence height limitations in place. Importantly, the alleged hardship, insufficient security with a 4-foot fence, is not caused by the physical characteristics of the property. Instead, it relates to concerns about visibility, trespassing, and activity occurring on or near the site. While those concerns are understood, the zoning ordinance requires that hardship be inherent to the land itself. Because of the previously mentioned reasons, standard B1 is not met. To find an unreasonable hardship, standards B1 and B2 must be met. As B1 is not met, an unreasonable hardship cannot be found. Staff unintentionally grouped together standards C and D. Standard C is regarding if the hardship is self-imposed or economic. Standard C was not addressed in the report and is being addressed in this presentation. Staff determined that the hardship is not self-imposed and is not purely economic. The applicant's building was constructed approximately in 1909. The position of the adjacent buildings creating hiding areas is due to the newer setback zoning requirements. And additional security measures cost could increase security, but some level of trespassing risk would remain with the 4-foot fence height. In summary, although staff understands that the applicant's safety concerns, the zoning ordinance requires specific standards to be met for a variance to be granted. Some but not all of the standards are being met, and for this reason, staff recommends that the appeals hearing officer deny the variance request. If the request is denied, the applicant will need to bring the fence into compliance by reducing it to 4 feet in height within the front setback area or relocating taller fencing behind the primary facade as allowed by city code. Is there any questions that I can answer?
Yes. So at the time the fence was constructed, I note that no permits were obtained to construct the 6-foot fence. Were permits required for a 6-foot fence at that time?
Yes, I believe permits are required for fencing. Regardless of whether it's 4 or 6 feet, they would be required to be obtained.
One other thing that I'm in evaluating this, I'm trying to think through, is if conditions on neighboring properties can create a circumstance that's peculiar to the property in question. And so, for example, in thinking through this, if this property was surrounded on 3 sides by a river that's not on the property, does the river surrounding the property, can that create a unique circumstance that's peculiar to that property, even though the river is not actually on the property? And I'm curious the city's thoughts or position on that.
If the property could still be developed, regardless of that, I don't know that there would be a hardship there. But I don't think there's anything specifically here that excludes a potential external condition from creating a negative impact on them. And we haven't made the argument that that the buildings can't be considered.
Okay. Yeah, that's what I'm trying to decide is can I consider these buildings as creating, because obviously they, in some ways, function as a cliff, if you will, on each side of the property. Does that make that circumstance of the property unique? does it matter that it's a man-made construction versus natural topography in terms of creating that distinction?
I don't think it does. The standards don't speak to man-made versus human-caused, whether a cliff or a building. It does certainly create a unique circumstance on her property in general.
I think it does. And if I can mention, I'm John Anderson, I'm manager of the planning division. This parcel does have the same development potential as the parcels adjacent to it. So it does have unique circumstances today, but at any point in time, that building could be demolished and that lot could be redeveloped. So I think we would want to consider that as well.
Thank you. Anything else from the city that I should consider?
Well, I think we need to consider as part of the variance standards that, the connection between what the applicant is seeking a variance to and the conditions that, she claims make that variance necessary. I mean, there's nothing, other than, potentially creating the additional hiding spaces because of the, shall we say, you use the term cliff or walled in kind of nature of that property. Now there's nothing about the existence of those buildings that make a 6-foot fence as opposed to a 4-foot fence necessary.
Okay, yeah. So in other words, going back to my river example, if the request for variance was for a bridge, that might be applicable given the circumstances. But if the request for variance was
a pool,
a pool, or keeping with the fence, I want a 6-foot fence instead of a 4-foot fence, that would not relate to those unique circumstances.
Correct.
Okay.
Just so I'm understanding this correctly, just because my lot size is similar, I'm not allowed a fence. I'm not allowed a 6-foot fence.
So, and
just because my lot size is the same, but you're not going to take into consideration that everything around me is completely different.
And Ms. Silver, if I can address this, I engage with questions with the city so that I can understand their position and how they're interpreting the legal standards. I also understand from your arguments how you would like me to interpret those standards and treat property beyond just the 4 dimensions of the lot. And so in what I have to do is now take under consideration all of the legal standards as well as the evidence and arguments that are presented, and then make a decision based on the application of those facts and evidence to the legal standards based on those interpretations. So I don't want you to get the sense that in discussing this with the city, I've made my mind up on how this is going to be determined. It's part of the process to engage in and asking questions to understand how the interpretation that they're advocating for. I may or may not agree with that, but that's part of what we're engaging in.
Mm-hmm.
And so I am taking into consideration your argument that more than just the square footage of your lot has to be considered when it comes to consideration of the term property.
I appreciate it.
So, Ms. Silver, with that, is there, we'll kind of put the final word to you as the appellant. Is there anything that after discussion that you'd like me to consider? Any other arguments you would like me to consider?
No, I think I tried to present it as best I can. I think I do see the city's, trying to look at it legally and stuff like that. I don't know if justice is served by saying tear it down to a 4-foot fence because the lot size is the same as all the other properties. But I don't know how to better present this. So, I presented it as good as I can. I think it obviously looks like I am different than what is surrounding me. You know, the landscape has definitely changed in the last 10 years. So I don't know how to better protect my small little property than to do that. So, and I have been there for 15 years. And so yeah, that's all I can say.
Thank you. And I understand your arguments. I understand the frustration and the position that you're in. So I am going to be considering both sides of the argument, both your arguments and the city's arguments, and seeing how those match up to the standards that by law I'm required to apply. With that, I will also be taking this matter under advisement, and I'll be issuing a written opinion, hopefully within the next 10 business days.
Okay.
I believe that concludes all matters that were set for this hearing today.
Yes, thank you, Clayton. And with that, we're going to end the meeting.
Thank you all.
Thank you.
Thank you.
Thank you.